all rise. Please be seated.
Good afternoon and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honour. This is case KSC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Good afternoon, Your Honour. Good afternoon, everyone. The prosecution team is represented today by Jack Smith, Specialist Prosecutor, myself, Cezary Michalczuk, SPO Prosecutor, Silvia Diascoli, Associate Prosecutor, and Artemis Hatzistavrou, Associate Disclosure Officer.
Thank you very much, Mr. Prosecutor. Now I turn to the defense, please.
Thank you very much, Your Honour. Good afternoon, everybody in the court. The defense is represented by myself, Julius von Bonnet. I'm the defense counsel for Mr. Mustafa. And Mr. Mustafa, he is today following the court session from the remote location at the detention center.
Thank you very much, Counsel. And for the record, I'm Nicholas Kiyu, pretrial judge for this case. On 2nd December, I scheduled this third status conference for this case. My objective today is to review the status of the case and to organize exchanges between the parties and to ensure an expeditious preparation for trial. I see that no written submissions have been filed by either of the parties. And I also note that no preliminary motion was filed by the defense by the time limit set forth in Rule 97. I will ask the parties for their submissions in turn, according to the scheduling order, first on disclosure, then on investigations, then on points of agreement on matters on law and facts, and finally on the next procedural steps. As usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. So I would first like to hear from the prosecutor on the first point of the agenda, namely whether there have been any difficulties in the disclosure process and whether the parties foresee any difficulties related to the remainder of the disclosure process. I also invite the prosecutor to indicate whether the SPO still has exculpatory evidence in its custody, control, or actual knowledge that must be disclosed to the defense pursuant to Rule 103. Mr. Prosecutor, you have the floor.
Thank you, Your Honour. Before I move on to addressing all the points of Your Honour, I would like to make a few preliminary remarks, if I may. At the outset, I would like to express the general position of the prosecution regarding the cause and the pace of this pretrial process. As the disclosure is now at an advanced stage and we are gearing towards its end, at least on the part of the prosecution, it is the SPO's intention to finalise the pretrial phase of the proceedings early next year and to move to the trial phase of the case as soon as possible and shortly after the filing of the pretrial brief and related Rule 95.4 material. Having said that, we believe we should all strive for commencing the trial as early as March 2021. Later during this conference, I will address all the points that Your Honour put today in the agenda, and I'll provide more precise information. When it comes to the problems with disclosure, at at present, we are facing none. I would like to brief Your Honor very shortly about what we have disclosed so far since the last status conference. On the 16th of November, we disclosed to the defense all material under Rule 102, paragraph 1, point B, that did not require redactions, and this batch contained in total 369 documents contained on 1,226 pages. Later on the 1st of December, the SPO also disclosed all witness-related material under Rule 102, paragraph 1, subparagraph B, that required redactions, and it all was contained in 139 documents on 1,991 pages. Also, we disclosed to the defense, as required by Your Honor's framework decision on disclosure, a detailed notice of evidence under Rule 102, paragraph 3, and we are talking about a total of 390 documents. This is the list that contains 390 documents in English, Albanian, and Serbian language. The prosecution, shortly after each disclosure, sent to the defense emails explaining the content of each disclosed batch. So when it comes to, as I said before, when it comes to difficulties that we are facing so far, we are not facing any. We are meeting all our disclosure obligations. Shall I continue, Your Honor, with the exculpatory evidence that we still have in our possession and control? Your Honor, addressing this point, the prosecution still has exculpatory evidence in our control and possession. We are, however, proceeding swiftly, and the exculpatory evidence that we find in this process is provided to the evidence on a rolling basis. The next evidentiary batch under Rule 103 will be provided to the defense most likely already later on this week. We keep digging, we keep checking our batches of evidence. We expect that the next review will lead to the further disclosure of evidence under Rule 103, and we will disclose this evidence to the defense early in January. There might be, and there will be, we know that already, there will be a need to seize, Your Honor, for the ruling on the matter of some reductions that will be needed for one of those exculpatory batches before it is disclosed to the defense. And we expect to file an application to Your Honor in the first half of January. We cannot still determine the date, but we will try to proceed extraordinarily quickly, especially bearing in mind my preliminary remarks that we aim at finalizing this process very, very quickly. We also still conduct several, we transcribe the interviews that we have so far conducted, and there might be also a need to take a look at their content and decide whether to disclose them without reductions or to, again, seize Your Honor for some reductions before the material is indeed disclosed to the defense. One way or the other, we'll be providing to the defense everything what we have under Rule 103 on a rolling basis as soon as we discover such material. When it comes to investigations, this was one of the points.
Yeah, it's another point. We'll first hear from Mr. Fonboni about the disclosure, and then we'll go back to investigations, if you don't mind.
Of course, Your Honor. We don't. Thank you.
Thank you, Mr. Prosecutor. Mr. Fonboni.
Yes, Your Honor. We've received the disclosure material that has been provided by the prosecution, including a very long list. I would probably later on wish to discuss that particular list in a closed session.
Did you face any difficulties, or do you have any issues with the batches that you got, or is everything fine on your side?
No particular issues, no particular difficulties, but one particular issue that is going to be addressed.
Thank you, Mr. von Bonny. Now I turn back to the prosecutor for the second item on your agenda, which is the status of its ongoing investigation. In particular, have you completed the investigative steps mentioned during the last status conference, or can an estimated date of completion be given? And are you in a position to confirm that the pretrial brief and related material under Rule 95.4 will be filed towards the end of February 2021? Mr. Prosecutor.
If I may, I will address both points separately. So let me begin with investigations. At the last status conference, indeed, we announced that there are still some remaining steps that need to be taken, and most of those steps have already been taken, indeed. The investigation is not still fully completed. There is a very small number of such steps that we have still that we have to take that are simply required as an investigative follow-up. But we are almost at the end of this investigative process. Nonetheless, Nonetheless, as we indicated at the last status conference, even if we have still something to do, those investigations will not impact on disclosure process and any of the deadlines, especially contained in Your Honour's order. And also they will not impact on our readiness for trial. I will address the readiness of trial in due course. As I already mentioned, we believe that this case should go early next year to trial, and we are preparing accordingly. I must also, at the end of this point, addressing this point, I need to emphasize that our office is not conducting only investigations in this case. We also conduct investigations in other cases. The evidence found there could have impact, sometimes big impact, also on this case. And accordingly, we have to bear in mind that our obligation towards the defense is to also analyze that evidence found in other cases and to disclose that evidence to the defense. This is why I cannot say that we have completed everything, because it's not only one case, it's not only one type of proceedings that we are looking at. Nevertheless, what I want to say, we will continue to promptly comply with all obligations, disclosure obligations, in respect of any newly found material. When it comes to the pretrial brief, now the disclosure process is much more advanced than I could report during the previous status conference. So with a higher degree of precision, I can provide Your Honour with a date for the moment when we can file the pretrial brief. We will file it on the 15th of February next year. I'm talking about not only the pretrial brief, but also related Rule 95.4 material. Thank you.
Thank you, Mr. Prosecutor. Duly noted for February the 15th. Mr. von Bonny, I would like to ask you now to provide an update about your investigations. In the last status conference, you mentioned that you were planning to go to Kosovo early December. And can you also provide an update on how much time you will need to finalize investigation activities? And I also invite the defense to inform me if it has the intention to give a notice of an alibi or grounds excluding responsibility, pursuant to Rule 95.5, and or to make requests concerning unique investigation opportunities, pursuant to Rule 99.1. Mr. von Bonny.
Thank you very much, Your Honor. I would like to address an issue regarding the materials that have been provided by the prosecution. And to be on the safe side, I would like to do that in closed session because I think that I'm going to name a number of to name names which I do not wish to disclose.
Then, Mr. Fonboni, we will move to closed session until further notice. So I will ask the court officer to move into closed session. And please let me know when we are in closed session so we can continue with Mr. Fonboni.
Your Honours, we're in closed session.
Mr. Fonboni, you can proceed.
Thank you very much, Your Honor. The issue is the following. I've received a very long list of documents that are disclosed. Not all of those are, in fact, disclosed, I believe, to the defense of that complete list. But there is one general observation that I would like to make regarding this matter. If I see it well regarding witnesses, I see a number of witnesses which are people who are identified in that list, people who are mentioned as a pseudonym, and people who are, so to speak, unnamed. As far as the pseudonyms is concerned, I have identified 13 of those, and the question regarding that would be whether previous statements of all of these people, I can name all of the witnesses by pseudonym, if you wish, but I can also say that these are 13 of these. They start with W04393, and the list goes on and on like that. And I think it is very important for the defense, and not only for the defense, but also for the trial chamber in particular, to see whether these people have been either testifying in different cases, that is question one, whether those testimonies can be or will be obtained if they have indeed testified in those cases. And it could also be that the pseudonyms could be presented or might have been presented as an injured party in some kind of case. And we think it is important for the trial chamber to determine the reliability of people. If I read a number of the statements, I have seen that the prosecution questions a particular witness regarding a previous testimony, but I have not been able to see that testimony in the documentation that has been disclosed. And I think it is very important because it is not going to be the first and probably not the last case in which we will see that particular people are testifying in several cases, and I think it is important for the reliability of those witnesses, so that we can see what they have been overall stating. Then I have seen two, what I would say, United Nations mission in Kosovo witnesses, which were unnamed, witness A and witness B. I have not yet read those statements of those people, but once again, these people, we should know whether these people have made previous statements or whether they have made whether they have testified. And for these three groups, identified, pseudonyms and unnamed witnesses, it is important not only to seek what they have testified in a trial, if they have, or what they have testified in some kind of investigation. Of the total number of the documentation, I have identified at least 232 documents that I would like to inspect further, or at least take a good look at. And I think it is important that we will know, for example, if we see that an investigation was stopped, against whom was that in fact that investigation, and which witnesses the investigation relied on vis-à-vis a particular suspect in such a case. And now I have seen only, for example, a decision about somebody who might have been a suspect. He's unnamed, but I did not get clear on what basis that was done. So once again, it has been in previous trials seen as well, whether it was in the Rwanda tribunal or at the Yugoslavia tribunal. We've seen those kind of cases happening, that some of the witnesses appear in different type of cases, and they might give a different statement, or they might give the same statement regarding a different suspect. In the many years that I've been working on this type of cases, I've come across that many times, and I think that is an important thing to determine. So I would like to know from the prosecution, actually, whether the witnesses identified, pseudonymed or unnamed, the three groups, have been either testifying or making police statements previous in whatever case. And if that is the case, then it is the belief of the defense that that material should be brought to the trial chamber and become part of the entire case file, so to speak. If you wish, I can name the pseudonyms. If you don't wish, and it is clear, then I did not want to file it as a document, because then I had no idea how to classify it, public or whatever, and I do not want to harm in any case any investigation or any pseudonym. I'm not sure whether witnesses are watching or viewing this trial, and I want to make sure that we can determine at some point their reliability, and I think that would be an important part of it. Sometimes we also see people who present themselves as an injured party in a particular case. I have not seen questions regarding that in the witness statements that I've read until now. But I think nevertheless it is important, because then we can determine for what injury a particular person has been presented in a particular case. And that can, of course, determine the timeline and the location of that particular witness in a particular case. And that might either conflict or not conflict his overall reliability, and I think it is important to do that. I've discussed it with my client regarding the statements, and we would really like to have that to surface in this case. That is the issue that I wanted to discuss in a closed session. I thought it would be wise to do it like this, and if you determine it different, then I'm open to that. And wait for the response maybe now. Then afterwards we can go into open session. I can address the topics that you have requested from me.
Absolutely. Thank you, Mr. Van Bonnet. Before I give the floor to the prosecution, I just want everybody to bear in mind the decisions I've issued on protective measures, because I think I've already addressed part of this in my decisions. But, Mr. Prosecutor, you have the floor on this generally, because we're not discussing about one witness in particular as for now, but more on the question in principle. You have the floor.
Yes, Your Honor. The purpose of the list that we provided under Rule 102, Paragraph 2, is to give to the defense the outline of what we have in general in our possession, any evidence and any material that we, the prosecution, have. Documents behind the list that he wishes to inspect, exactly in view of what he's talking about right now. So what is behind the list? What evidence the prosecution has for him to make a determination how to best prepare and present his case? So I would encourage the defense to take a look at the list and come to us within the deadline with the proposed list of the documents he wishes to inspect. When it comes to other questions, my learned friend mentioned a few points. Also, one of them is the question of reliability of witnesses in general.
the pseudonym that I've identified, I'm unable yet to determine whether the previous statements are complete, but if the prosecution would say today that that is complete, then we probably will not have any, any surprises during the trial. But I wonder whether the prosecution can make a final assessment on that, or whether that should take some additional work. Of the documentation that I've received, I have identified at least 232 pieces of material that I would like to inspect in the coming month, and that is sometimes quickly and sometimes it takes a little bit longer, so we will need to take some time for that as well. Thank you, Your Honor.
Mr. Prosecutor, do you wish to reply?
Not too much, really, in the response. Really, as I said before, after my learned friend inspects the documents behind the list, he will know exactly whether any of those witnesses gave the statement in the past or not. Some of them did, indeed. Some of them they didn't. This is just the list. This is just the indication of what we have. To have an informed position on that, my learned friend would have to really read the documents behind it. And this is my reply. It's hard to go beyond that for the purpose of this hearing, Your Honor, and not to prolong it too much. Thank you.
Thank you, Mr. Prosecutor. Mr. von Bonnet, I think the next step now is probably, according to my framework decision on disclosure, to request the documents by Friday, 8 January. And once you have access to all the documents and you've been able to inspect them, that you see if you still have questions, because it seems that some of your questions might be answered by the documents you will have access to. So I suggest that we go for this next step, and we'll assess after that if there is still a need for your request. I just want to add that the reliability of witness is usually assessed during the trial, so it's also one of the functions of the trial. So it doesn't have to be done at pre-trial, even though it's always good to be prepared and to avoid lengthy debates. But still, this is one of the functions of the trial.
Well, the reason why I address it, Your Honor, is that at some point it is also possible that the prosecution drops a particular witness. And so, of course, it is the final determination of the trial chamber. However, it is up to the prosecution whether they want to move on or continue with a particular witness, or whether they say, well, we will not or not anymore rely on the witness for whatever reason. So that is why I'm putting that at the table right now, because if there is a change of position of the prosecution regarding the number of witnesses, then of course that changes a little bit the debate too. I did not get clear, and I would like to have that from the prosecution, whether because in my view the list of documents, as long as it is not completely disclosed to the best of my knowledge. If I'm wrong, then please tell me. But what I would like to know from the prosecution is the witness statements that were previously done by those witnesses, is that to the best of the knowledge of the prosecution complete, so that we don't have to search for new things or whatever.
Thank you, Mr. van Wely. Mr. Prosecutor?
The list of the witnesses that the prosecution relies for our case, of course, also includes, to the best of our knowledge, of course, all the previous statements of these people. There are several witnesses, however, we don't rely, but we don't, as my learned friend put it poetically dropped it. We didn't drop any of those people. We simply decided at some stage that the value of their evidence is of such a sort that we as the prosecution don't need it. However, as required by the rules and the law, all this evidence is contained in the file. So even if there is a witness, to give you an example, on the evidence list, we have several named people. Some of these people interviewed by our prosecution office are named by the name and the surname. For example, these ones are those whom we interviewed in the past, but we as the prosecution are not going to rely on. Nevertheless, they are there, and they are waiting for my learned friend to come and inspect their statements. Yeah. So this is my short answer to that. So we don't drop anything. And to the best of our knowledge, the list that we provided on the 1st of December, the relevance list, contains exactly what is relevant for the case, not only for the prosecution case, but what is in general relevant for both of us, for both parties to these proceedings and also to the court later on to make a determination on the facts and the law. Thank you.
Thank you, Mr. Prosecutor. Mr. Fonboni, does it answer your question?
Yes. If I can address one short part again, which is within the list there is a number of named people of whom the detention was terminated by someone. It depends a little bit. The list is not really clear on that. The question is of that list of whether there is going to become some insight of where these people were actually detained and for what reason they were detained. That is one part. Another issue, Your Honor, that I would like to do is that the witnesses that have pseudonyms, the defense would like to know whether the prosecution has done any investigation regarding the criminal record of these people by some kind of authoritative institution. We would like to know that whether among the list are people who have a criminal record, and if so, if that criminal record exists, whether it can become part of the case file or not.
Mr. Prosecutor, on this question and after, I'd like us to move back to public session as soon as we've finished with this issue. Please.
Of course. Thank you, Your Honor. My quick answer to that will be that, according to the law and the rules, the prosecution is, of course, obliged to collect all the evidence in favor and against its case. And we also were gathering all exculpatory evidence alongside the inculpatory evidence. So everything we have managed to find is there in the bundle. So it's now, I believe, the job of the defense to simply take a look and see what we have found. If there is anything missing that the defense would like to collect, this is a good moment for the defense to conduct its own investigations if he deems it necessary at this stage. Thank you.
Thank you, Mr. Prosecutor.
Well, obviously, it's difficult to investigate whether a witness has a criminal record if that particular person has a pseudonym rather than a name. So that gives a complication to the investigation of the for the defense. So it's easy to put the ball on the side of the defense regarding this matter, but we are unable, of course, to know who the witnesses are. But if they were, or if they have criminal records, and what kind of criminal record that would be, that of course is relevant. But it is impossible for the defense to investigate such thing as long as we have pseudonyms regarding those issues. So I would like to know whether the prosecution will maybe go an extra mile in that perspective for that kind of research, because we are unable to do that.
Mr. Prosecutor?
Of course, we appreciate that the knowledge about the criminal record is relevant for the defense and also for the prosecution. It could impact on the credibility of a certain witness or witnesses. We agree. We might conduct additional checks, but again, I also encourage the defense, if he only can, to conduct also his own investigation. But we can double check this particular element. To the best of our knowledge, there is nothing that could be relevant for this issue, if I can say so. But we can definitely double check this particular one, bearing in mind that these witnesses are indeed, many of them are protected witnesses, and indeed the defense doesn't have even the name to give to the criminal record in Kosovo for the information that he would be willing to get. We'll discuss this issue internally. I think this is a valid point. Thank you.
Thank you, Mr. Prosecutor. Mr. Fonboni, anything to add on this? So the next step will be for you to provide the prosecutor with a list by 8 January and enter in discussion about this last point. And I also want to remind you that the protected witnesses are protected under my decision, so this can only be varied by a decision that I would make. So this is something that the prosecution cannot also do by itself. Unless any of the parties has anything to add, we will move to public session. Madam Court Officer, please proceed.
Your Honor, we're back in open session.
Thank you, Madam Court Officer. We are now back in open session. And Mr. Fonboni, I will get back to you to follow up on the questions that I mentioned earlier, namely the status of your investigations, if you already know if you intend to give a notice of an alibi or grounds excluding responsibility, and if you wish to make a request concerning unique investigative opportunities. You have the floor, Mr. Fonboni.
The short answer is on both issues that I do not have an answer on that yet. So that is both on point F1 and point F2. The answer is that I do not have yet that intention. What I heard just before the court session started is, and that will affect the investigation of the defense, is that the defense noticed that shortly before the start of this court session, it was in the news that we will probably go in the Netherlands in a complete lockdown, effective tonight, 24 hours, until the 19th of January. So, not sure how locked down a lockdown is, but it is the severest measure until now. The Prime Minister will give a statement at 7 o'clock this evening, and what I've heard is that there will be a complete lockdown. So that will certainly affect the opportunities that the defense have to either travel to Kosovo, which has until not been able to do. That is basically what I have to do on the status of the investigations. How long it will take, I would say an estimate would be about 9 months for sure.
Thank you, Mr. Fonboni. Mr. Fonboni, I understand that you might be limited by the corona measures. I also understand that you might not have all the information needed to finish your investigation, but I would really advise, and if possible, that you can proceed with investigation as soon as possible, because we do not want to delay too much the end of this pre-trial phase. So as soon as you have the possibility to travel to Kosovo to proceed with investigations, I invite you to proceed as expeditiously as you can.
I will, Your Honor. Thank you very much.
Thank you, Mr. Van Bonnet. Mr. Prosecutor, nothing to say on investigations?
Just one line to address what my learned friend has just said. As we said, our intention is to very quickly finalize the disclosure process, very, very quickly file the pretrial brief and related documentation, and as quickly as it is only possible to move to the next phase, trial. The indication of my learned friend of 9 months of investigation, starting probably from next year at some point, is rather concerning with regard to the time frame that we are envisaging for this case. Of course, it's not all dependent on us, and I understand that the defense should have time to conduct the investigations, but perhaps we should think of ways to address this issue. For example, we've got to maybe assess the extent of the lockdown measures proposed by the Dutch government. Maybe they will not prohibit any foreign travels. Maybe there is a way to conduct investigations in a different way rather than by the Defense Counsel himself going to Kosovo. Maybe there are other ways that he could employ to conduct those investigations and advance his case. I'm saying that also because we have a defendant in detention right now, and we should also bear it in mind to move as swiftly as we can. And this is the obligation not only of the prosecution, but also of the defense. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Mr. Van Bonnet, I fully appreciate the need for investigations from the defense, but I really urge you to be as expeditious as possible because, as the prosecutor said, we cannot depend only on the opening of the borders with the corona measures, and we have the possibility to benefit from exemptions from traveling as an international tribunal. There is certainly also a possibility to conduct investigations remotely when it's a question of having access to some documents. So I really invite you to be as expeditious as possible. We will discuss later in this status conference when could be the target date for the beginning of the trial, but it is clear that the length of your investigation will be a key factor on this. Now I would like to have the views of the parties on points of agreements on matters of law and fact. And I would especially like to know if they have entered into discussions regarding to the possibility to submit points of agreement on law and facts pursuant to Rules 95.3 and 156. And if it were not the case yet, when would the parties expect to be able to identify a list of issues subject to dispute? Mr. Prosecutor, you have the floor.
Thank you, Your Honor. Let me address both issues jointly, if I may. Pursuant to your instruction, we indeed engaged in the discussion with the defense on the points of law and facts, subject to an agreement that we could reach. We discussed that issue over the phone last Thursday. We're going to continue this discussion later on this week. We are already thinking about the short video conference on this matter. Independently of that, at the beginning of next year, the prosecution is going to prepare a document of the issues or points of facts and the law that the prosecution would like the defense to consider and potentially agree. So we are going to engage in discussions, but at the same time the prosecution proactively will prepare a comprehensive list of points that we could potentially agree on. Our deadline for that we are envisaging for the provision of such a list to the defense is tentatively 15th of January of next year, but perhaps we will manage to even provide this list earlier. Thank you.
Thank you, Mr. Prosecutor. Mr. Van Bonnet.
Your Honor, it's a complicated issue from the side of the defense, as the defendant, Mr. Mustafa, has been fighting for the liberation and the independence of Kosovo. So in general, I would say that it's hard to agree on points of facts or points of law regarding it. But obviously, the issue is whether we can at some point see whether the particular parts of facts or particular parts of law can be agreed on in order to speed up the trial. That is obviously the essence. I just want to reassure from the side of the accused that Mr. Mustafa is obviously in a situation that he thinks, why on earth am I accused at all for this fighting and fighting for the independence and the liberation of Kosovo. So on that part, Your Honor, we have indeed, I've received a phone call from the prosecution last Thursday, and we concluded that at some point we will engage in a discussion in order to see whether we can agree on points of law or facts or not, and whether that is possible for the 15th of January. I'm not sure how the timeline will develop, but we'll work on it. That is basically what I can say. And then we see what we can come up with to you. We've been previously working on a chart, so I think that in that perspective we can do that. Lockdown or no lockdown, that does not hamper our discussions via Zoom or whatever. But, well, we'll see how that goes. There is the intention to finalize that as quick as possible. Thank you very much.
Thank you, Mr. Van Bonnet. As you mentioned, Mr. Van Bonnet, it's a very important step to prepare for the trial because it will allow both parties and the trial panel to focus on the elements that really are at stake. So even if Mr. Mustafa do not agree with most or all of the facts, I'm sure there is still a possibility to agree on the law at least. And so I invite you to continue your dialogue with the prosecution and to get back to me with a list that you can agree upon in the following weeks. Mr. Prosecutor, is there anything you want to add on this?
Not on this particular point, but I would like to underline that we will proceed swiftly to compile this list of facts, and then the rest will depend on to what extent the defense will be agreeing to that or not. That's basically. Thank you.
Thank you, Mr. Prosecutor. Mr. Van Bonnet, anything to add? Thank you. Let me now move to the next point on our agenda, which is the next procedural steps, and I will turn to the defense first. Mr. Van Bonnet, do you envisage filing a pretrial brief and related material under Rule 95(5) of the rules? And if so, when do you expect to be in a position to submit such a filing? You have the floor.
Your Honor, we have not determined yet whether we will do that. So therefore I cannot provide you at this moment a date regarding that.
Thank you, Mr. Van Bonnet. For the next status conference, Mr. Van Bonnet, would really appreciate if you could be in a position to answer the question so that we can prepare the next step and especially be ready for trial. I would now like to ask the parties of when they expect to be ready for trial, because pursuant to Rule 95(2), I shall indeed set a target date for the readiness of the case for trial. We will, of course, not decide on a date today, but I would like an indication from both parties about when the case file will be ready to be transmitted to the trial chamber, according to the estimates of today. Mr. Prosecutor.
Thank you, Your Honor. The SPO, and I mentioned that before at the outset of this status conference, that we estimate to be ready for trial as soon as the pretrial brief, our pretrial brief is ready, and we file the Rule 95, Paragraph 4 material. I indicated that our trial readiness date is 15th of February 2021, and we would be happy to schedule the trial, to organize the trial shortly after, as soon as possible. Thank you. Possibly in March, as I said.
Thank you, Mr.
Yes,
Prosecutor. Mr.
Your
Fonboni.
Honor. Of course, it's a little bit depending on the amount and the type of witnesses that we would like to present in the trial. That is obviously an issue that we are facing, and we will see whether that is possible to do that before the month of March. I am not sure at this point, but we're working on it in order to do that. In my estimate, I would say that it wouldn't be March, probably a month or so, or 6 weeks later, around that. So that is an estimate that I give as of, let's say, the January the 1st, because the month of December is nearly over, and I do not expect that this month we will be in a position to work on that. Basically, everybody in the world is having Christmas and whatever holidays, so the last 1.5 week of December is gone, and we have another week. So we'll work on the witnesses and see what we can come up with, and then in order to present it at some point. Thank you very much. And by the way, Your Honor, if I would have any earlier date, obviously, then I will make submissions regarding that, so that it is easier for all the parties to make a timeline for that. But I must say that we are also a little bit depending on third parties regarding this issue.
Thank you, Mr. Fonboni. Next, would either of the parties wish to raise any point which has not yet been dealt with? Mr. Prosecutor.
No points, Your Honor. Thank you.
Mr. Fonboni?
No, Your Honor, I don't think I have any other point to raise.
Thank you. Finally, Mr. Prosecutor, do you have any submissions on the date of the fourth status conference?
The prosecution doesn't have any preference as to the date. It could be January, it could be February. Everything depends on the needs and Your Honors and the defense preference. It could be either of those 2 months. Thank you.
Thank you, Mr. Prosecutor. Mr. Fonboni.
Well, there is a slight preference for the month of February to set a new court date.
Thank you, Mr. Fonboni. Mr. Fonboni, is there any specific milestone or event that you wouldn't like us to do the status conference before? I'm especially thinking about my framework disclosure, the decision on disclosure. Is there a specific step in the proceedings that you would like to have behind you for the next status conference?
Well, as I have identified a long number of things that I would like to take a look at from the list of the prosecution, I think that will take a little bit more time than normal. I've identified 232 issues of that list. So it's not only me. I also want to discuss it with my client, obviously, who is the person that we are primarily concerned about. And then we can together work on that and how we feel about it. And when obviously it is not necessary, then it is not necessary. But if we do feel it is necessary, the one thing that I would like to ask is how would the judge wants the defense to communicate with the prosecution regarding the things that we would like to inspect? Is that through a submission, or can we go directly into contact with the prosecution? We have together one email on which we can rely. I can simply put the list on it, and then we can set a date, or I think it will be a number of dates, to be clear, that we would like to inspect those topics.
You can proceed directly with the prosecution on this according to my framework decision, so feel free to reach out to the prosecution directly.
Thank you very much, Your Honor.
Sorry, finally, I would like to remark that judicial recess begins on December 21st and ends on 1st January 2021. During this time period, I will only be responding to urgent matters, so non-urgent matters should be addressed to the Basic Court either before or after the recess. This concludes today's hearing.
Your Honor,
Mr.
if I may, on the very last thing is, I obviously have meetings with my clients. Those are usually Zoom meetings. They are usually not longer than 1 hour. Obviously, that does not it's not the normal way of working, because usually with a case file like this, you are together with a client like a full day or so. So I really would hope that it would be possible that we are able at somehow to have a little bit longer conversations than only an hour. It's really, it makes it a lot easier to work on the case file together, and it will eventually speed up the trial as a whole. So I hope that at some point either registry or whoever can communicate with the detention center that we are not really completely locked into this tight schedule. And we have usually 2 meetings in a week. So it depends a little on the week, but the organizational thing as far as the DMU is concerned, they usually decide how and when and what day and so on. So it would be helpful that we can work a little bit longer hours and preferably more days at some point. Thank you very much.
Thank you, Mr. Van Bonnet. Have you raised this issue with the DMU or with the registrar?
I've only with the DMU, but I'll take a look how it can be done. But it would be really preferable in cases like this that we have like an afternoon or an entire morning. Obviously, there is different detainees too, but due to these COVID measures, I understand everybody's position and everybody's possibilities and impossibilities. But of course, it works very different when you are normally here, go to a detention center, stay there an entire afternoon, and then you can go through a case file like that. And now that is limited, and you have only so much time, and you have many topics to cover. So it just, in general, makes it a little bit more complicated. So the only thing that I would ask is whether, that would be made available a little bit longer by whoever could interfere in that. Thank you very much.
Thank you, Mr. Van Bonnet. I invite you to mention this next time you schedule such a meeting with the DMU. And it's also noted on the record that you wish to have longer periods of time in order to be able to have more productive meetings with your client. And if there is any issue on this, we'll discuss about that during the next status conference. But I hope that this will be able to be fixed directly with the detention unit. Anything else from any of the parties? Then this concludes today's hearing. I thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographer, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned.
All rise.